Hello everyone, I'm Anuj Nakade and welcome to LiveLaw. As you know, domestic violence is a social evil that persists in our neighborhoods and represents a large chunk of crime against women in our society. The Madras High Court has made a very relevant observation in one such case or judgment. The judgment was regarding the petition under section 482 of the Code of Criminal Procedure for quashing an FIR registered under the Protection of Women from Domestic Violence Act. The petitioner in this case was a man who had married a woman in 1989 and consequently had two children, both girls. Due to problems in the marriage, his wife at the time sought protection orders and residence orders under section 18 and 19 of the Protection of Women from Domestic Violence Act in 2010. The judicial magistrate passed an order granting maintenance of Rs 3,000 to the wife and Rs 5,000 to the children, along with an order to give protection to her in 2011. The petitioner then filed an appeal against the order granting maintenance in the Madras High Court, and in 2013, the maintenance to the wife was set aside, but the maintenance granted to the children was confirmed. However, in 2011, his wife preferred a complaint under Section 31 of the DV Act, seeking penalty for breach of protection order by the petitioner, and an FIR was lodged against him. The FIR was because it was claimed by the petitioner's wife that he had not been paying her maintenance as per the orders of the court. A single judge bench comprising Justice K.K. Ramakrishnan heard the petition. The counsel for the petitioner argued that the non-payment of maintenance could be recovered through the execution of an award under Section 125 or Section 128 of the Code of Criminal Procedure through a distress warrant or a distraint warrant, and the non-compliance with the order granting maintenance does not mean there has been a breach of protection order. He relied on a case of Sunish versus State of Kerala, where the Kerala High Court has held that penal provisions such as Section 31 would not apply to maintenance orders. However, the court noted that the procedure of enforcing a maintenance order by way of a distress warrant or distraint warrant could be very cumbersome, and the result of getting maintenance amount in a speedy manner is thwarted. The court noted that the Domestic Violence Act brought in penal provision of Section 31 to provide immediate relief to the women waiting for getting a determined maintenance amount. The court said, and I quote, "The legislature has the present DV Act with the penal provision with an intention of suppressing the mischief of delayed execution proceeding of maintenance award and to provide the speedy remedy to the victim to avoid further destitution and vagrancy." The court said that this transformation of execution of maintenance to a penal statute was to ensure social justice and to protect women and children. So, the court applied the principle of purposive interpretation and observed that the non-payment of maintenance allowance would amount to economic abuse. The court's judgment reads, and I quote, "By applying the above principles of purposive interpretation to the below extracted sections 2O and section 3.4 of the DV Act, this court without any ambiguity holds that non-payment of maintenance allowance would amount to economic abuse, and the same will very well come under the umbrella of breach of protection order." While doing so, the court also disagreed with the reasoning of the Kerala High Court. The Madras High Court said that the reasoning of the Kerala High Court saying that if wide interpretation is given to Section 31 of the DV Act, the courts will be overflooded with cases under Section 31 of the DV Act, and it is not the correct proposition according to this court. The court said that looking from another angle, where the courts are flooded with cases, it would only signify the faith of the people upon the judiciary, and the same is a good sign for the judiciary. However, the court also noted that the petitioner has been paying maintenance regularly, for which he produced relevant documents. So, the criminal proceedings started in 2011 against the petitioner for not paying maintenance were quashed by the Madras High Court. That's all we have for you in this video. If you'd like to read our report or read the Madras High Court's order, please visit our website at www.livelaw.in. Hope you found this video informative. If you did, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.